Also, in this case, this party is supposed to be
affidavit in opposition file.
yes, party is supposed to be appear by on this virtual mode from Delhi. From Delhi, suppose party advocate is supposed to be appear
Okay.
by a virtual mode. I think I have whether they have joined or not.
No.
Join it. Join it.
You are for respondent number 1.
Respondent. Your Lordship, I'm appearing for behalf of this Mr. M. Karu. So currently, your Lordship is on the way.
Who is for Union of India?
So your Lordship, respondent number 236.
236. Who is appearing?
I'm appearing also. As per last direction, Lordship, we have only filed our status report in the form of affidavit. Even the copy has been served to the.
Yes, we have received too. We have received.
Manoj, may I submit?
Yes.
I'm appearing on behalf of Mr. Mahmood Pracha here. He was supposed to appear for the petition. He's before the Delhi High Court today, Manoj.
Okay, you are appearing for whom?
The petitioner, Manoj.
You are appearing for the petitioner.
Yes, Manoj. Actually, Mr. Mahmood Pracha, advocate, he was supposed to appear, Manoj, but he's physically before the Delhi High Court today, Manoj.
Okay, all right.
We have received an affidavit also, Manoj. I'm seeking liberty to file a short response to this as well.
Okay, all right then.
I may be permitted.
Alright, Mr. What is your name?
I'm Mr. Jatin Bhatt, Manoj.
Alright, Mr. Jatin Bhatt, appearing for the petitioner. Alright, Mr. M. Kato appearing for him. M. Kato for 1.
I'm for 1, 4, 11, 18.
No, the land comes.
Well, I'm for 2, 3, 5, and 6. 2, 3, 5.
Additional advocate general. Kato is for whom?
Matlab, items, matlab, respondent number 2, 3, 5, and 6.
2, 3, 5, and 6. And Tapin is for whom?
Lordship, I'm for 1, 4, and 11 to 18.
S. Tapin for 1. Who is for 2? Tapin is for 2 also. 2 is Union of India. Yeah. Notice served or not?
Matlab, I'm appearing on behalf of respondent number 2 also.
2 also.
Yes.
My friend is.
Okay. For 2 also. Today, Mr. Tapin has filed an affidavit, isn't it? The learned counsel for the petitioner seeks some time to reply to that affidavit. Is it okay?
My lord.
Yes.
I'm
You want
grateful,
some
my
time?
lord. Yeah.
You want some time?
Yes, my lord.
Seek some time to file a reply. After hearing both sides, his prayer is allowed. When do you want it?
2 weeks,
Up to-
your lordship pleases.
After 2 weeks,
My lords.
least up to 2 weeks. Okay.
Can I request my lords for a specific date if convenient to my lords?
Your Lordship, I'm for the respondent number
May I
3
plead
here.
to your lordship?
Last time, actually, I was directed to file additional affidavit, my lord. So I could not file, my lords. I may please be granted 2 more days, my lord, 2 more days.
2 more days.
Yeah, 2 days. Within 2 days, I will file, my lord.
Your lordship may see the order dated 12/9/2024.
12/9/2020.
Yes, 12/9/2024. May I read that orders? On 22/11/2020, this court has observed that additional affidavit filed on behalf of the state has not disclosed whether draft notification or rules by laws has been published in the official gazette or not. It is also not disclosed by the state authority that whether there is an actual implementation of solid waste management on the ground. This court has granted time to the learned additional senior government Arunachal Pradesh to place the status report before this court on the next date. Again, the matter was listed on 29/4/2024. However, it's appeared that the required affidavit has not been filed by the state. In such circumstances, we direct the learned counsel for the respondent to file an affidavit explaining that why the draft notification or rules bylaws has not been published in the official gazette, and also indicating that by what time the authorities such as Itanagar Municipal Corporation are going to set up solid waste management treatment for the twin cities of Itanagar, Nahalagan, and also to give a timeline that by what time garbage collection dustbins extra would be placed at the suitable places in the twin town. So this was direction. It's a long back. Lordship, direction was not only to the municipal corporation, it was direction to the state government also, Your Lordship.
My
But
lord,
then it's
I am the answering deponent, my lord. I am the answering respondent, my lord. I will file it within 2 days, my lord. And regarding this solid waste management, my lord, it has been notified, my lord. But I want to bring that into record, my lord. It has been notified already and under implementation. And regarding this solid waste management, solid waste plan, my lord, the solid waste management plan, my lord, that is under construction, and we are about to bring it within next 6 months, my lord. That also I want to bring in to record, my lord, within 2 days.
We will give him 2 days
Yes,
time.
yes, Your Lordship.
Heard Mr. S. Mao, preparing for the petitioner. Learned counsel, Mr. T. Jamo. Preparing for the respondent.
Number 3, my lord.
Respondent number 3. Praised for 2 days for filing the affidavit, explaining as to why the as to when or as to why the draft, notification or rules stroke bylaws have not been published in the official gazette. And he was also directed to indicate by what time the authorities such as Itanagar Municipal Corporation, etc., are going to set up a solid waste management treatment plant for twin cities of Itanagar and Nahalagan. The respondent was also given some time.
And garbage collection also, my lord.
Given the respondent was also given a direction to provide the timeline by which the garbage collection, dustbins, etc., would be placed at the suitable places in twin towns. Para. Mr. Zamu submitted that the garbage disposal plant will be operational within the next 6 months, isn't it?
Solid waste management plan, my lord.
Demo submits that solid waste management system will start functioning from the next 6 months. We have considered the submissions made by the learned counsel both sides. The prayer of Mr. Jamoy is allowed. Release this matter on next Tuesday.
Okay, my lord.
Next Tuesday, give the date.
All right, my lord.
Oblige.
Item number 3 and 4.
Your Lordship, Lordship, in item number 3, as per the office note dated 21/2/2025, unserved notice upon respondent number 4 has been returned back, Your Lordship.
In item number 3.
Item number 3, Your Lordship. Item number,
You want to take fresh steps.
Your Lordship, respondent number 4. Respondent number 3 is represented by SK Diori, and respondent number 4 was one of the respondent in original writ petition, Your Lordship. So
Respondent number 1.
1 and 2 is represented by
1 and 2
government,
also.
and
1 and 2.
No.
yes, Your Lordship. And respondent number 3 is represented by SK Diori, who was the original writ petitioner in the writ petition, Your Lordship. And respondent number 4 was one of the private respondent, Your Lordship.
Notice not yet served.
No, it
What
report,
you will do now? You will take fresh steps.
all right, Lordship.
Hard MS so appearing for the. Hard MS and Anju
Lordship.
appearing for the petitioner. Hard Mr. S. Kapin. Senior government. advocate.
No, sir.
Senior government advocate appearing for the respondents 1 and 2.
1 and 2.
The respondent number 3 is represented by advocate
SK Diori.
SK Diori. Service of notice of the respondent number 4 is not yet complete. Therefore, the applicant is directed to take fresh steps for service of notice of the respondent number 4 by registered postal date.
Lordship.
By registered postal date. Is there any interim order pending?
Yes, that is until further order.
Least after 4 weeks. The interim order pasture lesson continue until then.
And Your Lordship, in item number,
Least after 4 weeks, along with item number 4.
item number 4 also, Lordship, as per the office note dated 21/2/25, respondent number 5 and 6, the notice has been returned back. He also- Unserved notice has been returned back.
In item number 4, you right? Hard Mr. MS and Anju appearing for the appellant. Hard Mr. S. Tapin, the learned senior government advocate for respondents 1 and 2. Notice upon the 3, 4, 5, 6 not yet served.
Lordship, that has been returned back, Your Lordship.
Return the-
3 is represented by SK Diori,
Then you right.
4, 5 and 6.
Respondent number 3 is represented by the learned counsel, Mr. S. K. Devi. And the 4, 5, 6.
4 is still awaited, Your Lordship, as per the office note dated 25/3.
Want to wait again?
Yes, Your Lordship. In respect of
Await for the service report in respect of respondent number 4. And 5 and 6.
that, unserved notice has been returned back, Your Lordship. We will take fresh steps, Your Lordship.
The appellant is directed to take fresh steps for service of notice of the respondents 5 and 6.
5 and 6.
By registered post-it ID. List after 4 weeks, along with item number 3.
Obliged.
Is there any interim order pending here?
Yes, Your Lordship.
The interim order past LS will continue until then.
Obliged.
Item number 5.
May I please
Yes.
pass? As per last order, this appeal has been prepared by the relative of the accused.
Mhm.
So we need to correct this. As per latest judgment, it need to be appealed by the convicted person himself.
Non-appeals for the.
So we may,
Actually, notice upon the. Condonation of delay.
yes, sir.
Is it a delayed file? Delayed filing?
Yes, delay along with main case. Main appeal.
So there should have been an interlocutory application for condonation of delay.
Yes, we have already filed it.
Huh?
I think that was not listed.
Now, first of all, you file a condonation petition.
No, condonation we have already filed,
Delay already condoned.
not condoned, but it was not listed today.
Oh, so it is not listed today.
Yes,
It has to be listed. The
El-
order has to be passed in-depth condonation petition.
yes, sir.
The learned counsel, Mr.
K Dabi,
K.
Dabi.
Dabi, appearing for the one appellant or several appellants? One appellant.
Appellant.
Appearing for the appellant submits that he filed an interlocutory application for condonation of delay in filing the appeal. The delay is already condoned. The delay is already condoned. Delay 5 days. Delay of 5 days.
Yes, 5 days.
Then I will admit the appeal.
Yes, sir.
Oh, and the accused has not filed the appeal.
Yes, it was filed by the authorized person. It was a practice, all practice, but there's a judgment in this regard. The convicted himself has to file appeal
yes,
to
sir.
authorize. So we may be allowed to correct the course letter of the main.
Okay. Heard Mr. DW. KW.
You know, apart from this, there are 3 convicted persons in this case that may be clubbed together. 3 appeal, 2 other appeal is pending.
2 other appeals are pending.
Yes, criminal appeal number.
They will be clubbed together.
Yes, that.
Heard Mr. KW appearing for the appellant. This appeal has not been filed by the convicted person. Rather, it was filed by his authorized person. Mr. W submits that he will make necessary corrections in the title page of the memo of appeal by including the appellant himself in place of the said authorized person. There. The prayer of Mr. Dabi is allowed. Necessary corrections shall be done in the title page of the memo of appeal by implementing the convict and by deleting the name of the authorized representative shown there as the appellant. How much was the conviction?
You know, this is death sentence.
Date,
Yes.
least after 4 weeks.
Apart from this, you know, this notice has been completed. No? Notice has been completed.
The first of all, you make the corrections.
Yes.
Then other things will come.
Obliged.
In this case, whenever I'm again on behalf of caveat, so caveat may be discharged. Suppose the continuation is concerned, I need some time to file objection.
Is it a condonation petition?
No,
Yes.
Lordship, condemnation is of only 35 days, Lordship. I think my senior friend have no objection. Rather, Lordship, if
Because that.
my senior friend do not object, Lordship, delay can be condoned today and matter may be taken up next week.
I have the instruction from my client to file objection. Because there is some official correspondence now, how far it is. allowed.
Okay, let him find the objection then.
Lordship. I'm expecting big heart from the senior Lordship.
I'm ready. Otherwise, I cannot take that to my client.
Heard Mr. Stopping, the learned senior government advocate, appearing for the applicant. Heard Mr. AK Progastner. appearing for all the respondents.
One to four.
Huh?
1 to 4.
1 to 4. How many respondents are there?
Five respondents.
Cut is for 5.
Yes.
Hundred learned council, Mr. A.K. Protester appearing for the respondents, 1 to 4. Heard Mr. M. Kato appearing for the learned M. Kato, the learned deputy Solicitor General of India appearing for the respondent number 5. Mr. Protester submits that he has instructions to file an objection. Therefore, he prayed for some time. After hearing both sides, his prayer is allowed. When he will file the objection?
Matter is fixed on 7th of May.
List this matter on 7th of May.
Lordship, contempt is there, Lordship. Contempt is there, Lordship. They already filed contempt. And if it's listed, Lordship, in the month of May,
And the agenda matter, content matter.
then it's.
Okay, all right. In the caveat, you write, heard Mr. A.K. Protester appearing for the caveat, the caveat stands discharged. Okay.
I'm sorry for the inconvenience.
Obliged, Lordship.
Item number 7.
Tapak was here. Where is Tapak?
Tapak was just, he was here.
Notice was issued to the Advocate General.
Lordship, can this matter be posted for tomorrow? This is represented by this Monojit Vishwas from Guwahati,
No,
and he could not come today. I'm
no,
told that
no.
he will come tomorrow.
Apart from that, notice. was
Lordship,
issued to the
tomorrow
Advocate
may not be possible because learned AG will be appearing.
No, here it is written as notice to the learned Advocate General of Arunachal Pradesh be issued, for which
Yes.
the learned counsel for the petitioner shall appropriate steps.
So he will suppose. AG को appear करना है. आप लोग steps लेंगे.
Then any other date may be fixed.
Heard Mr. T. Tapak appearing for the petitioners. Heard Mr. S. Tapin, the learned senior government advocate, appearing for all the respondents. On 26/11/2020. Oh, this is not the last order. Really hard. On 26/11/2020, this court wanted to hear the learned Advocate General of Arunachal Pradesh, and therefore a direction was passed to issue notice to him. Thereafter, the case is going on. Without the presence of the learned Advocate General. Therefore, Mr. Tapin prays for some time to serve the notice upon the learned Advocate General. Arunachal Pradesh. His prayer is allowed. List after 4 weeks.
Lordship, in this matter may be adjourned for today.
Okay, all right. Heard Mr. S. Tapin appearing for the appellate. Heard Mr. G. Tato the learned advocate, additional public prosecutor for the state of Arunachal Pradesh. On a request made by Mr. Tapak, the matter is adjourned today. When do you want it?
After weeks.
List next week.
Next week.
Your Lordship, I am appearing on behalf of H. Jerem,
Yes.
the leading counsel for the petitioner.
Hmm.
Your Lordship, he is out of station.
Okay.
Kindly, a next date may be given as per convenience of this honorable court.
What is your name?
H. Jerem,
No,
on behalf of H. Jerem.
you are appearing for H. Jaram. What is your name?
O. Pangam.
The learned counsel, Mr. O. Pangam. Appearing on behalf of the learned counsel, Mr. H. Jaram. Submits that Mr. Jaram is not available today, and on that ground, that adjournment has been called for.
Your Lordship, the PP is absent as well.
None appears for the state of Arunachal Pradesh. The prayer of the learned counsel for the appellant is allowed. When do you want it?
Your Lordship,
When do you want it?
after 2 weeks time,
Least after 2 weeks for hearing.
much obliged.
Yes.
May I submit? My lord, item number 19, my lord.
Yes.
This matter, my lord, I am praying for withdrawal of the case, my lord, with liberty, my lord. Withdraw the case, my lord, with liberty, my lord.
You want to withdraw it?
Yeah. With liberty, my lord.
The learned counsel, Mr. L. Parme, appearing for the petitioner, submits that he has instructions to withdraw this writ petition. Here for the respondent,
Yes, your lordship.
heard MS Sensei appearing for the state respondents. After hearing both sides, the prayer of Mr. Parme is allowed. Liberty is granted to file it afresh. The present writ petition stands disposed of withdrawal.
My lord, additional, my lord, I beg to mention item notes 7, my lord.
7.
My lord. Here, with consent of the other side, my lord, I am praying the listing of matter after 3 weeks, my lord.
The learned counsel, Mr. L. Parme, appearing for the petitioner, prays for an adjournment and also submits that he has already taken consent from the other side. Accordingly, the matter stands adjourned today, least after 3 weeks.
Obviously,
Wait, your lordship.
Yes.
My lord, item number 21. My lord, the parties are proposed to have a negotiation. So it may be given by some longer date.
Longer date.
Yes, my lord. After 3 weeks,
21 days in I. The learned counsel, Mr. T. Son,
and I have taken the consent also.
appearing for the petitioner submits that both sides are thinking about a settlement,
Yes, ma'am.
and therefore Mr. Son prays for some time. The learned counsel further submits that he has already informed the other side. Accordingly, the matter is adjourned today. When do you want it?
My lord, after 3 weeks,
May.
3 May.
3 weeks. After 4 weeks.
4
Least after 4 weeks.
obligement.
May I please, your lordship?
Yes.
Your lordship, I beg to mention item number 1.
1.
Yes, your lordship. Your lordship, this item may be adjourned for 2 weeks, your lordship, because the conducting counsel, Miss G8, she is having some health problem, your lordship.
Okay. So you were appealing for Mr. Koyan.
He is for private respondent.
Yes. I'm appealing. Yes, Koyan. You were appealing for the government advocate.
Yes, 1 and 2, your lordship.
1 and
Respondent.
2. The learned counsel, Ms. So-and-so, appearing on behalf of the respondents 1 and 2, has prayed for an adjournment. Also heard Mr. S. Koyang, appearing for the respondent number 3. Heard Mr. Have you taken consent?
Yes, your lordship.
MS so and so submits that she has already taken consent from the petitioners. Accordingly, the matter stands adjourned today. When do you want it?
After 3 weeks, Your Lordship.
Least after 3 weeks.
Obliged.
May I please, Lordship?
Yes,
Lordship, I beg to mention one unlisted matter, Lordship, for withdrawal, Lordship.
for withdrawal.
Lordship.
May I, my lord?
Hmm.
My lord, I would like to mention item number 23, my lord. I'm for the petition, my lord.
23.
Yes, my lord. And I have taken consent from the respondent, my lord.
You want
Kindly,
adjournment.
yes, my lord. Kindly this matter may please after 3 weeks, my lord.
What is your name?
T. Minky.
The learned counsel, Mr. T. Mingi. You are appearing for Opada.
Yes, my lord. On behalf of Papa.
Appearing on behalf of Mr. Opada, the learned counsel for the appellant, prays for an adjournment and also submitted. And also submits that he has already informed the other side. Therefore, the hearing is adjourned today. When do you want it?
After 3 weeks.
Least after 3 weeks for hearing.
Your Lordship, I would like to mention item number 18 for adjournment. The leading counsel allowed item number 18.
18.
18. Leading counsel is also out of station. Your Lordship will kindly matter may fix after 2 weeks.
The learned counsel, MS so and so, appearing for
Yes.
the petitioner. You are for the petitioner.
So, Your Lordship?
You are for the petitioner.
Yes. No,
Appearing for the-
respondent.
Huh?
Respondent.
For the respondent.
Yes.
Oh, and Dangen is not present today.
Your Lordship?
Dangen is not present today.
Yes, no, Dangan.
Achha. The learned counsel, MS so and so, appearing on behalf of MS N. Dangen, submits that MS Dangen is not available today, and on that ground, an adjournment has been prayed for. Have you informed the other side?
Your Lordship?
Other petitioner side, have you informed?
Yes.
The learned counsel submits that she has already informed the other side. Accordingly, the matter stands adjourned today. When do you want it?
Next week, after 2 weeks.
Least after 2 weeks. Okay. Yes.
Your Lordship, with the consent of the counsel for the petitioner, I'm paying for the adjournment of item number 24.
24.
Yes, Your Lordship. On the ground that Mr. Lemi Bam, who is the conducting counsel in this matter, is out of station and personal
he-
difficulties.
You are for a respondent.
Yes, Your Lordship.
I forgot your name.
Alba.
Now I remember. The learned counsel, Mr. Alba, may pay for a respondent. Raise for an adjournment on personal grounds. And he has also informed the other side. Accordingly, the hearing is adjourned today. When do you want it?
After a week, Your Lordship.
Least next week
Highly.
for hearing. Yes.
My lord, I would like to mention item number 10.
10.
I am appearing on behalf of Deep Angan, the leading counsel for the petitioner.
Hmm.
Due to some health issue, my lord, he could not turn up for the court today.
Who
Kindly
is
the matter
who
may
is the
fix.
leading counsel?
Deep Angan,
Or Diki Pangan? Item number 10.
10.
The learned counsel, Mr. So-and-so, appearing on behalf of Mr. D. Panging, the learned conducting counsel for the petitioner, prays for adjournment. After hearing the learned counsel, the prayer is allowed. The matter is adjourned accordingly. Least, when do you want it?
After 2 weeks time.
Least after 2 weeks.
Also, my lord,
Hmm.
item number 25. I'm making the mention on behalf of H. Jaram. Matter may fix after 3 weeks time.
Have you informed the appellant?
Yes, my lord.
The learned counsel, Mr. So-and-so, appearing on behalf of Mr. H. Jaram, the learned counsel for the private respondent, submits that Mr. Jaram is not available today and under ground of adjournment has been prayed for. The learned counsel further submits that he has already informed the appellant. Accordingly, the hearing is adjourned today. When do you want it?
After 2 weeks time.
Least after 2 weeks for hearing.
Much obliged.
Your Lordship, I beg to mention item number 21.
21.
Appearing on behalf of respondent.
21.
Yes, Your Lordship.
21 already adjourned.
I don't know.
T. Son was appearing. It is already adjourned.
May I please, your lordship?
Yes,
Lordship, I beg to mention item number 9
9.
for sole respondent on behalf of the conducting council, Denzing Sonowal.
Just could be.
Item number 9
9.
for sole respondent. We are praying for
What are
4 weeks.
respondent?
4 weeks.
Hmm?
We are praying for 4 weeks.
Yeah, you are appealing for respondent.
Yes, lordship.
Why do you want adjournment?
Your lordship, the conducting council is out of station, your lordship.
Who is the conducting council?
Denzing Sonowal.
Oh, Denzing.
Yes, your
Sonowal.
lordship. Yes, lordship.
The learned council, Mr. Swenso, appearing on behalf of the learned conducting council, Mr. D. Sonowal, prays for an adjournment on personal grounds. Have you informed the other side?
Yes, lordship, yes.
The learned council submits that he has already informed the other side. According to the matter, it's adjourned today. When do you want it?
4 weeks.
This after 4 weeks.
4 weeks. Deeply applied.
Item number 2.
Lordship.
In the year 2022, he was arrested.
Yes, yes, Lordship.
Trial is in verge of completion, your lordship.
Huh?
Trial almost complete, your lordship.
Almost complete.
Almost.
Sir,
complete,
it is
your
in evidence, this, Lordship.
How many witnesses are shown in the charge sheet?
4 witnesses.
And how many of them are examined?
All of them examined, but FSL report is recently provided. Now FSL expert is yet to examine.
And today is the date, your lordship, for examination of the FSL expert. So now it's almost complete, your lordship.
No, you are not entitled to bail at this stage.
Lordship,
Mister? What is your name?
Deposit Bormon.
Deposit?
Bormon.
Bormon. Appearing for the petition of Mr. T. Ate.
Lordship, earlier it was filed before session judge.
No, you are not entitled to bail. Heard Mr. T. Ate, the learned judicial public prosecutor for the state of Arunachal Pradesh. Para. This is an application under section 482 of the BNSS 2022. The 483 of the BNSS 2022. Whereby the petitioner Liji Josam alias Liji Romin, who is facing the trial in sessions case number 51 of 2022, pending in the court of, in which court it is pending?
Session judge.
Session court, your lordship.
Session judge. UPI has prayed for releasing him on bail. Fair. In this case, 4 persons are shown as prosecution witnesses and all of them are examined. Mr. Ate submits that the case is about to be disposed of. And if the accused is released on bail, it will cause difficulty in disposal of the case. Para. I have considered the submissions made by the learned counsels of both sides. This court has reason to agree with Mr. Ate. This court holds that allowing the bail application of the petitioner would cause disposal of the case before the trial court. Therefore, the bail application is not considered at this stage. The same is rejected and disposed of accordingly.
Obliged, your lordship.
Item number 3.
Please, Lordship. Lordship, this is a joint petition filed by the petitioner in connection with Pasigat PS case number 74 of 2012, which is pending before the Chief Judicial Magistrate Pasigat.
At this stage, notice will go.
Lordship. Lordship, FIR was raised.
Yes, Lordship. Also, the FIR was registered on 7/9.
Show me the FIR.
FIR is at page number 17, Lordship.
Today, officer in charge, police station Pasigat, subject FIR Sir, today at around 1220 hours, I was hit by a Bolero AF near Mamang Borang oil depot. The driver is reportedly one Sri Kukut Talom of Rumgong village. Therefore, I request you to apprehend the culprit and take legal action.
Did he get any injuries?
Lordship, simple injury was there.
Simple injuries.
Yes, Lordship.
They are compromised.
Yes, Lordship. Settlement agreement is at page 43.
It is from Pasigat.
Yes, Lordship.
What do you say, Mr. Tadu?
Yes. Offense is punishable up to 6 months. Both sections.
Simple offense. It is first.
Yes.
Obliged.
First.
Obliged.
Well, this is something on the base of Mahesh Mukund Patil judgment on 28th of February by Justice Bhuyan. Well, before that, the applicant is the complainant, informant, and 2 is the accused. Well, the fact is, when the incident, they are family members, number 1. Number 2, they were having those relationships, and unfortunately, in 2022, Milord, she conceived, and then the accused is not the biological father. It is by the DNA profiling, Milord. It has come. I'll place that, Milord. Then secondly, Milord, what had happened was when the victim got conceived. In that, even what happened, there was a pressure from the family, Milord. There was a pressure from the family, Milord, saying that you have to disclose the father. So that resulted in, then the accused says, no, I have not done it. Then thereafter, Milord, ossification case was done. So from the commission of the offense and this particular point, then what had happened was, Milord, was shown 18 to 22 years. So if we take the higher side, normally we take it the higher side. Then at the time of commission of offense, Milord, she was, the victim was above 18 years. So then, Milord, what had happened finally, from the content of the FIR, Milord, I'll say that they are family relatives. And then thereafter, knowing the consequences, then there was a discussion in the family and they executed and this settlement was done. So from the FIR, Milord, just I saw, Milord, will kindly come to page 23. Maybe I'll say. Page 22, Milord, 20. 20, Milord. Yes. Milord, all those discussions we needed to read, Milord, kindly come to second page of the FIR, Milord, 21. Second paragraph, third paragraph I'm reading that I met the accused person for the last time in the month of February 2022 when I had so and so with the accused person. Few months later, I realized that I had received and became pregnant due to my physical relationship with the accused person. Since I could not share this news with any one of my family members, I desperately tried to contact the accused person to inform him about the news, me getting pregnant. However, the accused outrightly rejected my telephone and call and blocked my number as well. So, Milord, this is one point, Milord. Then, Milord, kindly come to next paragraph that I have highlighted, that despite refusal on the part of accused person to come to my rescue, I was hopeful that the accused person would mend his ways and fulfill his promise of marriage to me. Well, that was the Germany of whole thing. I took the decision to bear the child despite such attitude of the accused person that on 30/10/2022, I gave birth to a baby girl at Hema Hospital, Bangtinali, Itanagar. The copy of the birth certificate of the baby girl is annexed herewith and marks as so and so, my lord. My lord, kindly come to next paragraph. After Delhi, from there, my lord, from the circumstances, my lord, as has been reflected herein, it goes without saying that the conduct of the accused person from very beginning very clearly reflects his mala fide intention to so and so me and nothing else. His promise of so marriage was merely an excuse to lure and induce me into having so and so intercourse with so and so. The accused has intentionally manipulated, exploited, and played with my innocence and minor age and lured me having so and so. The accused person played fraud on me with the spite of so and so to consent enter into so and so.
187, 187.
187.
Then, my lord, he submitted his joining report on 18/1/2024 against the post of BO. That was a regular promotion in terms of the direction of the court. Then, my lord, they issued a charge sheet. Charge sheet is, my lord, then he was suspended on the same very day. The on which he joined on 18/1/2024, he was suspended in the latter part of the day. Then charge sheet was issued, my lord, height and extra and at page 196. Then, my lord, when he approached the court and matter was pending, some allegation was made in person. And the commissioner was made imputed as, my lord, party responding in person. When the matter was pending before the court, they issued two orders, my lord, by which, my lord, on the basis of, lordship will be, my lord, they satisfied to look at page 205. There is the impugn order, and by that impugn order, my lord, some punishment was imposed on the basis of an ex parte report. Ex parte report. On the basis of ex parte report, I was demoted from the post of BO to my original post TGT. Then on the next, my lord, moment, on the same very day, I was transferred, my lord, as TGT, not as BO. Therefore, palpably, this order is absolutely, my lord, not justified and deserves to be interfered by this honorable court. Or should examine this matter, and since it is a punishment transfer, as a lordship knows, my lord, punishment transfer is not permissible. Because if you want to impose a penalty, then you have to impose penalty, whatever is prescribed under the relevant, my lord, it could be disciplinary rules and conduct rules. Therefore, lordship will, my lord, stay this process, my lord, entire impugn order.
Stay, you have to wait for some time. Let the
Otherwise, my lord, lordship kindly appreciate. Ex parte, my lord, order, no inquiry report was supplied to me. In terms of Ramjan Khan case, my lord, you have to supply the copy of the inquiry report, even if it is an ex parte. There is no reflection, nothing of the sort.
Which is the impugned order?
My lord, at page, my lord,
205.
205. Two impugn orders. Two impugn orders.
One is 205 and one is?
One is, my lord, next page, 206.
206. One is
this is the imposition of penalty.
Imposition of penalty.
I'll kindly read the second paragraph. Whereas after careful consideration of inquiry report. What is the inquiry report? No copy was supplied. There is no reflection in the order itself. The copy was supplied. I was given opportunity to file representation in terms of Supreme Court decision. Ramjan Khan, there is a settled position of law.
Okay,
Nothing.
I will state these orders. Heard Mr. A.K. Broadcaster appearing for the petitioner. You are appearing for?
Sitting Council, Tabatagum.
You are appearing for Estapin.
Yeah, Tabatagum.
For
Standing Council, Education.
no, who is for one?
What is it?
1, 2, 3.
Your Lordship, I haven't, I just had informed from my senior that due to some difficulties, he's unable to come today. So matter may be fixed tomorrow.
No, tomorrow I'll not able.
No, there is not a problem. You are appearing for whom? Which one? Respondents? Which respondent you are appearing for?
I have no idea.
You have no idea.
Yes.
234.
234.
I get 234. 234.
234.
Yes.
Here, Secretary, Government of Department of Education. Is there any standing council for Education Department? Mr. Procaster?
My lord.
Do you know?
Park.
For standing council for, is there any standing council for the education department?
Yes.
Titagum.
Titagum.
Yes, Lord.
But today, Tagum is not present.
Yeah, due to some personal difficulties, he's unable to come today.
Oh, you are on behalf of Tagum.
Yes, yes, yes.
And then you are for 1, 2,
3 and 4.
3 and 4. For all of them. Heard Mr. A.K. Purata is appearing for the petitioner. Heard Mr. What is your name?
A Podo.
Appearing for all the respondents. Issue notice. No formal notice is required to be sent as because Mr. So has accepted notice. List of the 4 weeks.
7th May.
Yeah.
7th May.
On 7th May.
May. I will come.
List on 7th of May 2025. Till then, the operation of
Been order dated 10/3/2005 at pace
till then
196.
One.
Page 196.
Huh?
Page 196.
196.
No, 205. Sorry, 205.
105.
205. 205.
205. Yes. Till returnable date.
205 dated 10/3.
The impugned order dated 10th March 2025.
2025.
Passed by the Commissioner Education.
Commissioner of Education.
Government of Arunachal Pradesh.
Education Department.
And
next order.
And the order dated 10th March 2025.
Yes.
Passed by the
Same.
Commissioner Education, Government of Arunachal Pradesh. Shall remain stayed.
Obliged. I will supply copy. Obliged.
Yes.
Lordship matter may be passed over for time being as main counsel is engaged in court number 2.
Okay then.
My lord, the conviction is based on the on the depositions of the sole prosecutrix. Law is well settled, my lord. In Dola Singh also, my lord, the law said if it is consistent, even then there is a requirement under law, it must be corroborated with the evidences. But in this case, my lord, what had happened? Number one, my lord, I will be arguing on 2-3 points. My lord, what had happened? FSL report, my lord, even was not allowed to file in the church sheet. Number two, my lord, thereby, my lord, 207 CRPC was violated. And the law is well established on the facet of Article 21. Right to fair trial is a fundamental right. This has not been followed in this trial. Then second, my lord, the ground of my argument would be lack of medical evidences. And number two, my lord, number three, only on the number three would be on the whether the confessional statement made under 164 CRPC and 313 are a substantive piece of evidence, and the retraction made thereafter, my lord, can be discarded by the learned court while convicting. There are 3 grounds, my lord. Basically, I am outlining, my lord. Now, my lord, kindly come to the. Rama, can you take it as? My lord, I have furnished the list of book as well. Like I have all the copies with me, my lord. I have printed copies of this. Take this out.
Paper book.
Yeah, Telegram. Because my youngers could not escape this due to paper book.
Yes.
My lord, I will not burden my lord much. I'll finish and shorten as much as early, my lord. My lord will kindly come to the FIR at page 1. First, we see this FIR. I would like to inform you that today on 6th May 2022 at around 7:30 p.m. My lord will kindly mark this. In the deposition, the prosecutrix has not mentioned the correct time. This is Mr. So-and-so contacted me over mobile phone and visited my rented room located at Backside Bazar Line, Colony Sapa, in order to collect his wristwatch. My lord, I am pausing for a moment in this particular line. That means they are not alien to each other. They are known to each other. Two adults, my lord, known to each other. Once he entered my room, he locked the door from inside. Sensing his ill intention, I warned him not to touch me. He started threatening me of dire consequences. My lord, here the contradiction is, first, my lord, there was a telephone conversation between them.
They are known to each other.
Known to each other, and you allow him to enter to the room, my lord. The first suspicion, my lord. Does not accept to his proposal to marry him. He threw my mobile and grabbed my neck very hard and assaulted me. My lord, kindly mark this also, grabbed my neck very hard. Here, my lord, the doctor has not found anything while examining her. And she has also concealed one fact, my lord. Before, the purpose of coming was to collect the wristwatch as well as to see her because she met with an accident with scooty, my lord.
Is he still in judicial custody?
No, my lord. Yeah, he's still in the custody, my lord.
Better to consider
Just I place this corroboration so that my lord will give the release me, my lord. No, then what had happened, my lord? Kindly see, like I take one more thing, my lord. Only simple thing, my lord. Now, in her deposition, my lord, she says that there was a pool of blood, but the IO of the case, my lord, who visited the place of occurrence, my lord will see. Kindly come to page 70 of the paper book. My lord will kindly come to the cross by the defense, my lord, page 70. My lord, I cannot say whether victim came to PS alone as I was not present at PS during that time. After the case was endorsed to me and I was called over phone, then I came to PS and seen the victim. Apparently, there was no injury on the victim, my lord. One. During the time of apprehension of the accused, I, along with another officer, went to apprehend him. I was told about the location. I was not accompanied by the victim at the time of my PO visit. I have not found any foreign material seized from the PO, my lord. And kindly come to one aspect. Where is that? The position switch page. Victims, my lord. Kindly come to page 27, victim's statement, my lord.
27.
Yes, my lord. Which page? My lord, 28 is important, my lord. Page 28.
She's 25 years old.
25 years.
Grown up girl.
Grown up.
Yes.
Here also, my lord, kindly 1, 2, 3, 4, 5, 6. In order to avoid him, I immediately went out. Otherwise, also I had to purchase medicine for my allergy, my lord. I took out rupees 1,000 from type 1 ATM as the ATMs in the main market had no case. Thereafter, I purchased medicine from pharmacy beside Divan Hotel. I returned to my place at Backside Bazar Line. As I reached my place at 7:30 p.m. or so, Babin again called me and told me that he was there below my place. My lord, see, the suspicion starts from here. My place in the 3rd floor. He came up to my place and I offered him water bottle. He suddenly started to speak differently with me, which was making me very uncomfortable. And at the same time, he was touching me inappropriate. I sensed his intention and called my uncle's roommate in the 1st floor, so-and-so. I told him that I had to cook for my uncle and it was getting late. So I asked him to leave.
11 of 2022 shall remain stay till disposal of the connected appeal. Para. It is also directed that the applicant Sri Babina Hafi shall be released on bail or rupees 25,000 as a surety of like amount to the satisfaction of the learned session judge at Bomdila. In respect of sessions case number 11 of 2022. The IS stands disposal. In the appeal, you write, heard Mr. Titi Tara, lawyers are same. Lawyers' names are same. Paper book is ready. List this appeal for hearing in due course.
In due course. Grateful. I hear.
Item number 8. May I please also, madam?
Yes.
So in this case, I have made an interrogatory application only for correction.
Correction.
Correction. My lord, lawsuit prior question. Only, my lord, in place of CGM, my lord, that should have been, my lord.
This is item number 8.
8.
Criminal petition.
IA is that lawsuit had passed the interim order on 9/9. So in that order, my lord, there is a retraction of CGM in place of session judge.
Just a minute. Where is the order? In the IA?
You are to put 21.
In the IA, the order is not here. The last order.
My lord, at page 21.
31.
21.
21. 21 of this criminal petition.
Yes, ma'am. Called 21 of the IA.
21 of IA.
Of the IA.
But
last part, madam. Till the returnable date, further proceeding of GR case number so arising out of so
okay.
pending before the court of Lords, Chief Judicial Magistrate, come civil judge, senior. It should have been, my lords, done as session judge. Next page.
Okay. In the court of learned session judge.
Yes, madam.
Okay. Heard Mr. A.K. Protest the learned counsel. Yes.
So I'm trying for disposal of this matter, Lord.
No, no, today is not fixed for disposal.
Just a minute. This is for correction of the earlier order. Heard Mr.
Pleadings already completed, Lord.
Yes, yes.
Also,
So may I amplify for disposal, Lord?
Appearing for the applicant. Heard Mr. G. Tado, the learned traditional public prosecutor for the state of Arunachal Pradesh. Heard Mr. K. Lolen, appearing for the private respondent.
Yes.
This application has been filed, praying for correction of the order dated 09/09/2024, passed by this court in criminal petition number 58 of 2023. In the said order, it was directed that further proceedings of GR case number 87 of 2022, arising out of Kamba PS case number 07 of 2022, pending before the court of the learned Chief Judicial Magistrate cum Civil Judge Senior Division West Siang District, West Siang, District Alo shall remain stayed. Mr. Purokasta submits that the case is actually pending in the court of session judge.
Session judge.
Session judge, West Siang District.
Yes.
West Siang District Alo.
Yes.
Therefore,
West Siang District Alo.
West Siang, District Alo. After hearing both sides, the correction is made accordingly. Henceforth, the wards Chief Judicial Magistrate cum Civil Judge Senior Division West Siang, District Alo, appearing in the order dated 09/09/2024, passed by this court in criminal petition number 58 of 2023, shall be read as Sessions Judge West Siang, District Alo. This order is formed a part of the said order dated 09/09/2024, passed by this court in criminal petition number 58 of 2023. The ISN disposal. But so far as the criminal petition.
Main petition. Main petition may fix a date on 7th.
Okay, do it on the next date.
Yes.
7th May.
I'm coming. If you have any inconvenience. 22 other matters are fixed on 7th. only.
7th. Do you know 7th? A lawyer's name same in the criminal petition. A.K. Procaster, D. Tadu, K. Lolen. List this matter on 7th May.
And
7th. only.
on 7th, the endeavor shall be made for the disposal.
Endeavor shall be made
Yes.
to dispose of the case on the day.
Yes.
That's all right. Deeply obliged.
Obliged.
Sorry to interrupt you, sir. In item 7, sorry, in other argument, item.
Or in the I you want to.
Yes, in I have to press one because I asked my clerk.
Put it in the same record. In the I. Then what if you have not put it there? Criminal petition.
My lord, this dispute is between a father and his son, my lord, for stealing of 3 gas cylinders and some local ornaments.
Is this a joint petition?
Yes, my lord. FIR is at page number 21, my lord.
21.
With due respect, I am to inform you that one Sri Dhartitava, son of so-and-so, who is my second son, residing at Doimuk Police Station compound, has stolen away all my cylinder, 3 nose, man, and local bit 6 dal big size from my government quarter. The said accused sold all the mentioned articles for purpose of using drugs to other person at Doimuk area. Now I am sober, my lord. And this is a case of 2020. Now I'm residing with my family members. I'm sober and I'm not into drugs anymore.
Oh, see. Who files the
Father and son, my lord. Father and son.
But the informant is
Mother.
mother.
Yes.
Mother is a
Oh,
party.
in this case, mother and son.
Huh?
Mother and son.
Mother and son.
Yes, my lord. In the next case is father and son. My lord.
This is mother and son.
Yes, my lord.
Okay, it is cost. Is he a drug addict?
No, my lord. He was never addicted, my lord.
Mother says that he.
He used to have a drugs initially, but now he's sober and he's living together.
Okay.
My lord, in this case, my lord, at that point of time, he was one kind of an habitual offender. So therefore, my lord, this complaint was filed by the father, my lord. And the allegation is in respect of stealing away of the household items, my lord.
Yes, in 12, it is
Where is the FIR?
FIR is at, my lord, page number 18, my lord.
Page number?
18, my lord. My lord, the content is here, my lord. In serial number 12, man. Page number 18. 18, man.
18 is not the FIR. Operating part of the FIR. So written FIR.
Yes, ma'am, it's there. It is to copy of FIR starts from page number 17, ma'am. Page number 17, it starts.
But the written FIR is not here.
Written FIR is not there, ma'am. But the contents of the FIR is mentioned here in page number 18.
You should have filed the written FIR.
In that case, I'll try to find out the main FIR, ma'am. Since
File
this,
it tomorrow.
ma'am.
File it tomorrow.
Ma'am.
Leave this matter tomorrow.
Oh, like.
Number 13.
May I please, Your Lordship? Here in this case, Your Lordship, this is a bail application for a release of accused Asadul Ali, who has been in judicial custody for more than 36 days, Your Lordship. Here in this case, Your Lordship, the accused was arrested because of non-appearance during the trial. He was arrested because he was not appeared during the CC stage, Your Lordship.
Was he shown as an absconder?
No, Your Lordship.
Oh, earlier he went on bail.
Yes.
Earlier he went on bail.
Yes, yes.
Later on he defaulted.
Yeah.
Your Lordship, I have not seen such order, whether he was on bail or not, Your Lordship.
He was on bail, Your Lordship.
Then if you file the bail order,
Your Lordship, if you see the last order, that is page number 42, Your Lordship. That is on 30 October 2024, Your Lordship.
order dated,
Order dated 30 October 2024.
page number?
Page number 42. Here in this case, the court order, Honorable Session Judge said to pass an order. Both the accused persons were present.
Just a minute. 42. What is the name of the petitioner?
Asadul Ali.
Asadul Ali, Your Lordship.
Asadul Ali.
And moreover, Your Lordship, the offense under NDPS is section 27A, capital A is also there, Your Lordship.
No, on 30/10/2024, he was present in the court.
Yes.
Then
CC was fixed on 08/01/2024, Your Lordship.
where is the order? On Asadul is absent. However, is present.
Your Lordship, kindly see the page number 32, Your Lordship.
Medical certificate. Then
Your Lordship, what happened in this case, Your Lordship? On 8th of January 2025, Your Lordship, the last CC was fixed.
Yeah.
No, where is the order issuing non-bailable warrant?
It's page number
33.
32, Your Lordship.
32.
Yes.
Your Lordship, actually, in my humble understanding, Your Lordship, they ought to have challenged that order, not by way of bail application, because Your Lordship, if the condition has been violated, then learned court below has to cancel the bond. Then NBW issued. But Your Lordship, directly here NBW has been issued. Now, this until or unless this order has been challenged, Your Lordship, this will be operative. This will be in operation.
We should have challenged this order.
Yes, Your Lordship. Then automatically he will get bail.
2025.
If this is interfere, then automatically he will get the bail, Your Lordship. And there is no doubt, it's very apparent.
Do you withdraw this petition and file a separate criminal petition
Yes.
challenging this order?
Exactly, Your Lordship.
Then you will get whatever you want.
In bail, the court will only consider the, Your Lordship, the allegations, Your Lordship, not the order, any impugn order passed by the learned court below. Here, without no doubt, Your Lordship, without following the procedure, NBW has been issued. So he ought to have assailed this order, Your Lordship.
You withdraw it. Will you withdraw it?
Your Lordship,
because allowing bail will be difficult at this stage on the basis of this order. This order will remain as it is.
yes, Your Lordship.
You take a decision.
Okay, I will withdraw the case, Your Lordship.
You withdraw it, file a criminal petition challenging this one.
Yes.
Okay.
The learned counsel, Mr.
Tigame.
Appearing for the petitioner submits that he has decided to withdraw this bail application and to file a criminal petition challenging the order dated 09/01/2025 passed by the court below in NDPS case number 24 of 2023. Heard Mr. T. Ate, the learned tradition police prosecutor for the state of Assam. The prayer of the learned counsel for the petitioner is allowed. His bail application is disposed of on withdrawal. CD shall be returned.
Yes, sir. Obliged.
Obliged.
Item number 14.
Yes.
My Lord, this is a bail application, my Lord. Your Lordship, this is very interestingly, Your Lordship. This bail is not maintainable, Your Lordship. Why? Because, Your Lordship, the sections are bailable. Because, Your Lordship, the NDPS, there is that no obscenity clause, Your Lordship. There is a many clarification given by this honorable court as well, Your Lordship, that non-obscenity clause doesn't
it has not to be read with the heading that all the sections are non-bailable or cognizable. Non-authentic clause comes later, and it says all the offense will be cognizable. It doesn't speak about bailable or non-bailable. So CRPC will govern this. Now the offense, Your Lordship, under which the accused is booked is section 21A.
21A and 27.
That is for a small quantity. The punishment is up to
1 year.
1 year. And the second is section 27, Your Lordship, for 6 months. But now it will come under the, Your Lordship, under the category of, Your Lordship, schedule 1, part 2, where classification has been given. And Your Lordship, this issue has been come before this honorable court in many occasions, Your Lordship. These are the observations given by the coordinate bench, Your Lordship. First, initially, Your Lordship, in the Guwahati, Your Lordship, criminal petition was filed, wherein the bail was rejected for these offences. The same offence, Your Lordship, by Justice R.K. Fukan, Your Lordship, on 22/7/2019. Your Lordship will find in the second page of second last para, Your Lordship, third last, Your Lordship. The provision of 482 CRPC is not meant for invoking his jurisdiction in any other situation where alternative remedy is available to the party. The power under 482 is extraordinary. So I will come from next para. So far as section 21A of NDPS Act provides for punishment up to 1 year. And the learned court below is in a position to consider such bail prayer under 436. 436 is for bailable offences. And having regard to the provision of section 37 NDPS Act as well. Taking note of the above, the present petition is then disposed of the motion is itself with a direction to the petitioner to file a press bail application before the learned lower court, citing the relevant provision of law and decision of the Bombay High Court has been referred, and the learned court below will consider and dispose of the same in accordance with the law. Now, Your Lordship, here indicated section 436. 436 deal with the bailable offence. So now it clearly deal by our own court, and Your Lordship, again taking lines of the judgment, the coordinate bench, Your Lordship, our own coordinate bench, in bail application 73 of 2023, Your Lordship. Here also, Your Lordship, same section. I was present there, Your Lordship. Additional PP so and submit in view of the decision of the Bombay High Court rendered in AB number 1998 of 2021, decision in so and so, as well as the order of the court passed in criminal petition, this criminal earlier one, on dated the offence under section 21A/27 of NDPS Act is a bailable offence. In view of the above submission made by the learned PP, Mr. Junior Counsel for the applicant submit that this bail application may be adjourned and list after a week to enable the applicant to approach the learned trial court under 436A of the CRPC. The pendency of the bail application shall not be barred. Now, here in this case also, Your Lordship, basing on this order, they approached the learned court below and bail was granted.
This is also
same sections.
21 and 27.
Yes, same section. 21A and section.
Go to the trial court.
My lord,
Yes.
I have earlier approached the learned session court allow, my lord. However, the bail has been rejected, my lord. That's why I filed the successive application.
Actually, this issue was not raised before the learned court below.
That is why.
Now, with this clarification, Your Lordship may given them the liberty to approach the learned court below, Your Lordship.
Okay, heard Mr.
M. Doji, my lord.
Appearing for the petitioner, heard Mr. T. The learned petition for the prosecutor for a state of Arunachal Pradesh. But this is an application under section 483 of the BNSS 2023, whereby the petitioner Kento Bagra,
Yes, Lord, Kento Bagra.
comma, he is the accused.
Yes, he is the accused.
Okay. Whereby Kento Bagra, comma, who is under judicial custody in respect of ALOPS case number 14 of 2025. Where the allegations I have considered the submissions made by the learned counsels on both sides. Where the accused in this case is accused of the petitioner Kento Bagra. He is accused of committing the offences under sections 21 within bracket small a and 27 of the NDPS case. Right. It is a subtle position of law that these two offenses are punishable up to 1 year of imprisonment. In a similar situation, this court in criminal petition number 814 of 2019, 814 of 2019, had directed the petitioner to approach the trial court for seeking bail. As both the offenses are bailable.
Yeah, sorry, Your Lordship.
Both the offenses are bailable.
Both the offenses are bailable because
Both-
punishment are below 3 years. Your Lordship.
Both the offenses are bailable. Under the said circumstances, the present petitioner is directed to approach the trial court for seeking bail
Now, Your Lordship, 436 is 478 in BNSS.
bail under section
78.
478 of the BNSS 2023. The present criminal bail application stands disposal of it.
Yes. Deeply obliged.
Yes, the bail application.
Lordship, this is the anticipatory bail application, Lordship. Last
CD
time the
is also-
CD was called for.
CD received or not? Received. Where is the FIR?
Lordship, I am not named in the FIR, Lordship. You will find the FIR at
Page number?
17, Lordship. Lordship. Very short FIR, Lordship.
Oh,
Allegation is forging the signature of the Deputy Commissioner East Coming District
Hmm.
for obtaining a sanction order for carrying out work.
repair and maintenance work.
Correct, Lordship.
You are not named in the FIR.
I am not named in the
Um,
FIR. And then,
Where is the police forwarding report?
Lordship, we could not avail that police forwarding report, Lordship.
The reason why he was arrested?
Lordship, he was not arrested. This is an anticipatory
Or the AB?
pre-arrest bail.
Okay, all right.
I'm not named in the FIR, Lordship. And then
This is the status report.
Status report, it's very serious offense, organized by the nexus of the different persons from different districts. And one person in this case was arrested, Bengamakam, who confessed before the confessed under 164 rules. And he disclosed the name of this instant applicant
Oh, okay.
as a prime accused, as a mastermind of the entire episodes. They use their way of working is that they always carry the seal and stamp of the other official
Next
personnel.
Wednesday it will be taken up. Yeah, we take it with you. It will be required later on. Leave this matter next Wednesday.
next witness.
Next Wednesday. Give the date.
Lordship, item number 16 is also the
CD.
This is another FIR, but the allegation is the same.
It is the same FIR.
Allegation.
So, same day, Wednesday.
Item number 17.
Obliged.
None appears for the petitioner on call. List next week.
Item number 20.
Your Lordship.
Yes.
Your Lordship, earlier order directed by this honorable court, I have taken steps against respondent number 2, 3, and 4. And through the record, it's been found that service has already been completed. So I pray your Lordship that this matter may be fixed for admission hearing, your Lordship.
Okay. Notice already served upon?
Yes, your Lordship. Already, all the respondent have received.
Heard Mr. A. Bhattacharya, appearing for the petitioner, heard Mr. G. Tadu, the learned petitioner public prosecutor for the state of Assam. Service of notice upon the respondents 2, 3,
And 4.
and 4
They were the complainant.
is already complete. When do you want it?
After 2 weeks, your Lordship.
List after 2 weeks for admission hearing.
Much apologies.
Item number 22.
My lord, service has already been completed in this as well. I'll file an affidavit to bring into record. Service has already been completed, my lord.
Service is already complete.
Yes. I'll file an affidavit to bring into record.
Heard Mr. What is your name?
Mukbang Pertin.
M. Patin,
Yes, my lord.
appearing for the appellant. Service of notice is complete.
Yes, my lord. It's showing in the online record, online website.
But the service not yet complete in the respondent number 1 to 5. The office note says the service not yet complete.
I'll file an affidavit, my lord.
Huh?
I'll file an affidavit. Online, it shows it has been completed on the website, on the Indian Post website.
Oh, okay. The office note dated 25/03/2025 shows that the service of notice upon the respondents 1 to 5 is not yet complete. On the other hand, Mr. Partin submits that the notices were sent by speed post
Yes, my
and from the relevant website, and that the tracking system of the relevant website shows that the notices are served. Therefore, Mr. Partin prays for some time to file an affidavit to that effect. The prayer is allowed. List after 3 weeks.
much obliged.
Item 27.
List this matter after 2 weeks.
Your Lordship, maybe after the view break, Your Lordship.
Huh?
Maybe after view break.
After BU vacation.
Obliged.
You want to withdraw it?
Yes, Lordship.
The learned counsel, Mr.
K Tabang Lordship.
K. Tabang,
Tabang Lordship.
K. Tabang. Ketan Tabang,
Lordship.
appearing for the petitioner submits that he has instructions to withdraw this writ petition. After hearing the learned counsel, the
Lordship,
prayer-
liberty may be given to file afresh. Lordship.
the prayer is allowed. Liberty is granted to file it afresh. The present writ petition stands disposed of and withdrawn.
Deeply obliged.
Pass over matter, item number 6.
Standing counsels for the department to still at court number 2.
Court number 2. Then next week,
Lordship, this is an urgent.
next Monday. Heard, Mr.
Up to 28th, Lordship, there is a limitation period.
You are B. Arun.
Yes, Lordship.
Heard, Mr. B. Arun appearing for the
Lordship, tomorrow.
petitioner. Huh?
Tomorrow.
Tomorrow possible. Next Monday.
Urgency is there, Lordship. Otherwise, the filing of this writ would be defeated. Lordship.
Nothing is happening. Nothing will happen. Don't worry. Heard MS so and so, MS so and so appearing for the
1, 4, and 5.
respondents 4 and 5.
1, 4, and 5.
1, 4, and 5. He is also appearing. You are also appearing.
On behalf of forward. On behalf of leasing permits.
Leave this matter on next Monday. What will be the date? Monday is a holiday probably.
Monday is holiday.
Tuesday.
Lordship, if you allow me 3 minutes, then I will satisfy Lordship.
Lawyers are not present. How can I hear you alone? I have to hear both sides.
Tuesday, Your Lordship.
Hmm?
Tuesday.
Tuesday. In court proceedings, both sides are to be heard.
Yes.
If I hear you, I cannot pass any order without hearing the other party. That is the law.
Otherwise, Lordship, if we go on a Tuesday, then the filing of this instant writ could be defeated, Lordship.
Nothing will happen, nothing will happen. Don't worry. Here, everything goes slowly. Nothing is so fast. Okay?